seconds, 5 seconds. Start. By the impugned judgment, a full bench of the High Court came to the conclusion that neither under the DMC Act nor under the Delhi Development Act there was any power to seal property for its misuse, inter alia, holding that the power of sealing of premises is drastic, as by reason of such sealing a person could become homeless, thus affecting his human or fundamental rights, and that the power of sealing in relation to misuse has been intentionally excluded from the provisions of two acts. It is not in dispute that large numbers of residential premises are being misused for commercial purposes. The question is, can the MCD stop such misuser by putting a seal on misused property? For dealing with this question, it is necessary to examine few provisions of the DMC Act. Chapter 16 of the Act deals with building regulations and comprises section 330A to 349A. The definition of the expression building shows that it is very wide and encompasses any structure, only excluding portable shelter, with which we are not concerned. We are concerned with the building and its erection. The definition of the words to erect a building is very pertinent for deciding the present question. The expression to erect a building is defined in section 331. Clause C, H and J are very significant. These clauses bring in the concept of user of a building for the purpose of definition of the expression to erect a building in respect of an area where the notified land use is residential. Sanction for erection of a commercial building cannot be accorded. This takes us to the provision of sealing as contained in section 345A of the DMC Act. One of the objects is to contain massive conversions of residential constructions into commercial complexes. A plain reading of the aforesaid provisions show that sealing can be restored to at any time before or after making an order of demolition under section 343 or under section 344. Section 347 contains a specific prohibition for change of the use of any land or building. Section 349A contains the power of the central government to make bylaws for carrying out the provisions of Chapter 16. In view of the above, the petitions and appeals deserve dismissal with cost quantified at rupees 10,000 in each case. The official and officers will have to be informed that any dereliction of duty would be severely dealt with. Despite repeated orders of the High Court and this court, implementation of such orders is utterly lacking. If the laws are not enforced and the orders of the courts are ignored, the result can only be total lawlessness. It is therefore necessary to also identify and take appropriate action against officers responsible for this state of affairs. Action is necessary to check corruption, nepotism, and total apathy towards the right of the citizens. Similar would be the accountability of errant officers as well, since prima facie such large-scale misuse